Thank you for listening to this PYA webinar recast. PYA is pleased to offer this alternative way to access our thought leadership. This is a recording of a previously delivered webinar. The information is accurate as of the date of the original event. The video recording, slides, and associated material for this and all PYA webinars are available on our website at pyapc.com. This podcast is for educational purposes only. It is not intended to be used as legal advice or an official opinion.
Hello and welcome to the 7th annual Let's Talk Compliance Conference, co-hosted by Foley & Lardner and PYA. I'm Jana Kolarik, a partner in Foley's Healthcare Practice Group, and this is my co-host, Angie Caldwell, a consulting principal at PYA.
Thanks, Jana. I need to play historian here for a moment, and my apologies to the folks that have attended 3 sessions or multiple sessions, but we do have folks that are not attending all sessions. So I need to play historian for just a moment and comment on the fact that this is our 7th year of our annual Let's Talk Compliance Conference. Thank you, Foley & Lardner, for your partnership, for putting this on. Thank you to our subject matter experts for being available to present and share such great content with us. And thank you, Jana, for your co-hosting with me for 7 years. It's been so much fun.
It has been. Thanks, Angie. It's been great. Thank you for a great 7 years. It's been great to do this with you and coordinate this with you. Big thanks to the presenters, Ben and Michael today, and all the presenters for this year. It's been awesome. Good content. And I think we've grown from an in-person Florida with, maybe 20 people to national and hundreds of people and bigger every year. So thanks to the attendees as well. It's been fantastic.
Let's take care of some housekeeping. So, folks and attendees, your slides and handouts are available in the resources panel. That looks like a little cloud on your screen. You may enter questions at any time into the Q&A panel. That's the little box with the question mark in it. And to the extent that if time allows and our presenters are able, they may answer your questions or they will follow up with you after the event. Please get comfortable. This viewing experience is made for you, so you can enlarge the panels, you can make them bigger, that you can make them smaller, so that you are viewing what you want to view today. And you can even close them out to meet your preferences. So lastly, if you run into any technical difficulties, the first step is to refresh your browser, simply because we're all using internet services and sometimes things do lag out there. So just please remember to refresh if anything looks strange on your side. So let's talk about education credits. So PYA is offering CPE and CHC credit. For our CPE credit attendees, you must stay logged in the entirety of the session, and you must answer all 3 polling questions during the next hour. Once you've successfully met those requirements, you're going to see a CPE certificate available for download in the continuing education window, and you'll also receive a copy by email. CHC credit attendees, please stay logged in for the entire session. We'll be submitting information for those CHC credits, and it will take about 6 to 8 weeks following the event. The green box at the bottom of this slide, I want to draw your attention to that, is very important. Please be sure to complete the CEU survey located on your webinar dashboard. That helps us determine the type of credit that you are seeking. It is available to you at any time during the course of the next hour, so please remember to fill that out. We'll give you reminders throughout the course of the event as well. Jana, you want to tell us about CLE credit?
Yes. So Foley & Lardner is offering CLE credit. To be awarded CLE credit, you have to be logged into the session for the entire duration, and you have to record the 5-digit CLE code that will be announced later on the attorney affirmation form in the resources panel. So keep in mind, CLE guidelines prevent us from verbally announcing the actual code. You'll need to wait until the end of the program for the CLE code. You must be in front of your monitor for the full duration of the webinar to view that code at the end. I will give you, or Angie will give you, a heads up that that slide is up. You must sign and return the form after the session to LSHC Events at lshcevents@foley.com. CLE credits will take a little bit, so 8 to 12 weeks to process. So our second session today will be led by PYA's Michael Ramey and Foley & Lardner's Benjamin Dryden, covering the antitrust issues and provider mergers and acquisitions. And now we're going to turn it over to our presenters. Take it away. Thanks, guys.
Thanks, Jana. It's Michael Ramey of PYA. Great to be with you today. Very timely topic, very evolving topic, especially given the current landscape. So what we plan to do today, and especially Benjamin with his very detailed experience managing these complex laws, we'll be kind of going through, first of all, some general antitrust principles that healthcare providers need to be aware of, and also then get into some of the latest changes on the federal merger guidelines. That includes the impact on private equity investments that are occurring within healthcare. Also, in 2024, there were significant proposed changes that were put forth. We'll see how many of those are continuing to move forward, but significant changes to the federal filing requirements for certain proposed transactions underneath the Hart-Scott-Rodino Act. So we'll explore that a little bit, because that is certainly going to impact the transaction lifecycle and the process associated with transactions. We'll also talk about the even more prominent role that state officials have been playing within healthcare M&A. And then lastly, we'll have some fun and pull out the crystal ball and see what's on the horizon with the new administration. So with that, I'm actually going to turn over to Benjamin to jump into the details here.
Great. Thank you, Michael, and thank you everyone for joining today. We're going to begin with just some general antitrust principles that apply to mergers and acquisitions, just as a level set. So I'll begin with a very mild oversimplification that I'll reduce all of federal antitrust law to 3 sentences. These come from what I'll call the 3 key federal antitrust laws. Going back to 1890, the Sherman Act was the original federal antitrust law. And there's a picture on the screen of Senator John Sherman, the author of the Antitrust Act. If there are any Civil War aficionados out there, Senator Sherman was the younger brother of Union General William Tecumseh Sherman. Fun little historical anecdote. He was a senator, and he'd served as Secretary of State, Secretary of Treasury. In 1890, he authored the Sherman Antitrust Act. It was called the Antitrust Act because Section 1 of the Sherman Act begins with the language on the screen: every contract, combination in the form of trust or otherwise, and that's where the trust comes from in antitrust, or a conspiracy in restraint of trade or commerce is declared to be illegal. And this is one sentence that has stood the test of time. It's truly the most fundamental antitrust law of the land. It governs things like price fixing and bid rigging, but for purposes relevant here, it pertains to mergers and acquisitions. So if 2 companies come together, that is a combination in the form of a trust or otherwise that can plausibly be in restraint of trade or commerce. Section 2 of the Sherman Act, which again dates back to 1890, the same Sherman Antitrust Act as Section 1, pertains to monopolization. Every person who shall monopolize or attempt to monopolize shall be deemed guilty of a felony. Now, the Sherman Act doesn't prohibit monopolies, it prohibits monopolization. So what's the difference? If you have a monopoly through having, building the best mousetrap, just being a good competitor out in the marketplace and winning a dominant share through good faith competition, that's totally lawful. And that really is what the antitrust laws encourage people to be doing. So they say, making a better product, business acumen, even historical accident. If you were just lucky, the right place, the right time, and you achieve a monopoly fairly, then that's perfectly lawful. But monopolization is achieving or perpetuating a monopoly through something other than good faith, bona fide competition. So again, for purposes relevant here, a merger or an acquisition can, under the right facts, constitute monopolization or an attempt to monopolize. But the Sherman Act, this was the late Gilded Age. The courts kind of watered it down, and it became hard to enforce the Sherman Act to the fullest extent that Congress desired. So 24 years after the Sherman Antitrust Act was passed, Congress passed the Clayton Antitrust Act, which is meant to supplement, not replace, but just beefing up the prohibitions of the Sherman Act. And so the relevant section for purposes of today is Section 7 of the Clayton Act, which says no person shall acquire the stock or assets of another person, where in any line of commerce or in any section of the country, the effect of such acquisition may be substantially to lessen competition or to tend to create a monopoly. And again, this wasn't meant to replace the Sherman Act. It just reinforces it and draws the line maybe 2 or 3 steps closer to erring on the side of prohibiting business conduct. So what does this mean? If you ask the federal antitrust agencies, which are the Federal Trade Commission or the Department of Justice, let's say FTC or DOJ, they fixate on the word may. They pay less attention to the word substantially, but the FTC and the DOJ say, hey, Congress used the words may be substantially to lessen competition. Again, where the effect of such acquisition may be substantially to lessen competition. That may verb indicates that Congress's concern was with probabilities, not certainties. And this argument has prevailed in the courts. And so there's pretty high profile hospital merger case in 2016 where the court accepted this argument entirely and said, you know, all that's necessary is that the merger create an appreciable danger of lessening competition substantially or creating a monopoly. Doubts are to be resolved against the transaction. So us lawyers always talk about the burden of proof. And in a typical civil case, you just have to prove by a preponderance. You have to prove it's more likely than not that the elements of the case are met. Here, it's the standard is may be substantially less in competition. So courts have struggled with, you know, do you have to prove a 50.1% likelihood of lessening competition, or is it something less than that? The latest articulation is you have to prove a reasonable probability, which would imply something probably less than a 50.1% chance that a merger will harm competition, but it's not a 10% chance. Courts really struggle at where exactly to draw the line. But the way courts approach this is with the 3-step burden shifting process. The first step is the government, the Federal Trade Commission or the Department of Justice, or I should say a private plaintiff, because under the right circumstances, private parties can step into the shoes of the agencies and enforce the antitrust laws directly in court. But the plaintiff must show a proper market, meaning a geographical market and a product or service component, and then show a reasonable probability that the merger will substantially lessen competition in that market. This initial showing, this reasonable probability element, is usually shown with evidence of market concentration, things like market shares and overall market concentration. We'll unpack that as we go today. But then once that showing has been made, the defendants, which are in this case the parties who are trying to justify the merger, can rebut that prima facie showing with evidence that the merger will be either competitively harmless, because maybe there's a lot of other competitors out in the marketplace that will keep the market competitively disciplined after the merger, or even pro-competitive. You can say, hey, this merger is going to allow us to eliminate duplicative costs. We'll be able to pass those savings on to consumers. Then those synergies can actually make the overall market more competitive. So if the defendant successfully rebuts the plaintiff's prima facie case, then the ultimate burden of proof reverts to the plaintiff to rebut the defendant's rebuttal with whatever other evidence can be mustered. And I should say, this feels like, you know, a picture of a tennis match where the government lobs the ball over the net and the defendant lobs it back, and the government lobs it back. That's not really how it works. In court, in a litigated case, everyone's just trying to prove everything at once. But the way the court at the end of the trial is supposed to analyze the issues is following this 3-step burden shifting process. So the issues that come up are broad because, again, the standard is may the transaction substantially lessen competition in a market. And so there's a lot of ways that a transaction could substantially lessen competition. The touchstone, really the fundamental question is often, will the transaction result in price increases? And in the healthcare context, it's pretty well established, Medicare rates are set by government fiat, or workers' compensation reimbursement rates are set by state prescribed medical fee schedule. So where there is room for price increases are the negotiated prices negotiated with commercial payers. That's really what the focus tends to be. Will the transaction result in price increases for commercial payers, for commercially insured members? But there are other issues beyond just price increases. They look at, is there some head-to-head competition between the parties that are trying to merge that results in them having better quality or more amenities, things like free parking or reupholstered furniture in the waiting room, service lines, locations, access points. They also look at, will the transaction create other benefits? You talked about cost savings or economies of scale that might promote competition. Now, it happens all the time that you say, hey, there are benefits from this merger, but then the government will say, okay, sure, there are benefits from the merger, but are those benefits merger specific? Meaning, do you need to merge to achieve those benefits? And so a lot of times that becomes the issue. So these are the issues that a regulator will investigate and that a judge or jury will consider. How you go about proving that? There's a lot of various sources of evidence for any of these propositions. So a big one is, what do commercial payers say about the merger? The FTC will go and talk to the commercial payers and ask them and get their opinion. Are they concerned about the merger? Do they think it's going to be harmless? Healthcare being a quintessentially local service, the federal regulators will often look to the perspectives of local law enforcers or local employers or even local competitors. What are their perspectives about the merger? A big one is documents. What do the parties' documents say? Either what do the parties' documents say about the motives for the merger, or what do the parties' ordinary course of business documents say about competition generally? And beyond what do the documents say, the agencies have an ability to take depositions and get testimony under oath from the business teams about what do they think? Do they consider the target to be their primary competitor, or not really? And that testimony often carries great weight. And then another thing, particularly when they're looking at synergy arguments, is, well, what happened in the past when there were past M&A transactions, either involving the same buyer? Did they achieve synergies that were passed on, or did they not achieve synergies? Or they'll look at other M&A transactions in the same geographies.
Ben, one thing that I've seen more prevalent lately has to do with the evaluation, both the short-term and long-term effects on the labor market. You mentioned getting input from employers. Are you seeing the same thing? And if so, how are you seeing that play out?
Yeah, it's a very, very timely question. So I'll say 10 years ago, that would never have factored into the analysis, except insofar as they're considering synergies. If you bring together two, let's say, hospital systems, and you're able to eliminate a duplicative set of administrative staff or billing staff, that's pro-competitive. That would have been orthodoxy even 10 years ago. In the past 5 years, especially under the Biden administration, they kind of flipped that and said, wait, the antitrust laws not just protect competition for price competition, but also competition for labor. And so the analysis started to, under the Biden administration, look at things like, are the parties competitors in the labor market, such that bringing them together might give a disadvantage to, say, a nurse who's looking to play one employer off the other employer in negotiating a salary or benefits. And that's a difficult issue because often what's good for consumers, what's good for commercial payers and their members might be bad for employees. It's a two-sided market. So it's a very lively issue. It came up in one hospital merger investigation, in particular in Rhode Island. What I'll say is I expect this to largely fall by the wayside under the Trump administration. The philosophy of the Trump appointees is more oriented at, okay, what's going to affect consumers rather than looking at other stakeholders like workers. But it's a very lively and timely issue. Perennially, healthcare provider M&A is a top law enforcement focus of the FTC and the DOJ. Year after year after year, they'll bring enforcement actions in this sector. So just since 2020 alone, I've got 8 hospital mergers that the FTC challenged really in a 4-year period. Almost all of these result in either the FTC prevailing and blocking the merger or forcing the parties to abandon the transaction. So there's one exception and then a story. The one exception is the Thomas Jefferson Health acquisition of Albert Einstein Healthcare Network in Philadelphia. That was a litigated case where the parties actually convinced the judge that transaction was not likely to lessen competition. That deal was allowed to close. But that's the only truly litigated hospital merger challenge of this century, since 2000, where the parties have prevailed in court and been able to close the merger. The other really interesting example was the first one listed here. Novant Health was trying to acquire 2 hospitals, community hospitals from community health systems in North Carolina. And that was litigated, and the judge said the FTC had not proven its prima facie case, and the judge said that transaction would be allowed to close. But then the FTC appealed, and just the time that was going to take to litigate the appeal was enough to cause the parties to abandon the transaction. So they even won in a court of law, but the FTC still succeeded in blocking that deal. So when the FTC brings a challenge, it is difficult, not impossible, but difficult to win. And that really goes back to the burden of proof on the FTC is not very high. Another really interesting recent issue, and this is something that was not an issue 10 years ago, and we'll see what happens under the Trump administration. But there's been a really recent focus on private equity, and they use the term roll-ups. So the poster child for this is in September of 2023, the FTC sued U.S. Anesthesia Partners and its private equity owners, which are various funds associated with Welsh, Carson, Anderson, and Stowe, for an alleged roll-up scheme to acquire over a dozen hospital-based anesthesiology practices across the state of Texas. And you can picture they bought a practice in Dallas, and then a practice in Houston, and a practice in San Antonio, and then another practice in Dallas, and another practice in Houston. And as alleged by the FTC, every time U.S. Anesthesia Partners bought one of these practices, prices went up immediately. Anesthesia is just one of these core service lines. You really can't operate a modern hospital without having an anesthesiology practice providing services. And so it was a pain point. Interestingly, Welsh Carson was dismissed from the case because there weren't enough allegations that they were continuing to participate in U.S. Anesthesia Partners' roll-up scheme. But just last week, Welsh Carson settled administrative charges at the FTC and said, we're going to freeze our investment in this practice. We're not going to make any more investments. We'll limit our governance rights to only a single board seat, and we won't have the chair of the board. And they agreed that before making any further acquisitions nationwide of anesthesiology practices, they would go to the FTC and not only provide notice, but get the FTC's affirmative approval to allow them to make those acquisitions. So it's a pretty interesting case. But just more broadly, this is the poster child for this issue. More broadly, the FTC and the DOJ are increasingly looking at and being critical of the potential incentives of private equity on healthcare. So there's a general concern about the financialization of healthcare, and specifically about the short-term profit motives of private equity buyers. They're looking at things like, is there something that causes private equity to just be a bad steward of healthcare entities? And my use of the word steward was, pun intended. The Steward healthcare debacle that drew a lot of national attention certainly underscored this issue. So in March of last year, the FTC held a half-day workshop on the subject, and the FTC chair opened the workshop by saying, hey, we've got concern. Firms of all types should be on notice.
Yeah, man, I think it'll be interesting to see how things play out, especially use poster child as far as U.S. anesthesia partners, how much enforcement there actually is going to be, just because there are so many physician practice management companies out there that are private equity sponsored, and they're all doing these smaller tuck-ins to be able to build scale. It'll be interesting to see what level of enforcement I think will transpire over time.
Yeah, absolutely. And this issue of roll-ups is not at all unique to healthcare, but it just feels like a particular focus of the agencies. At least it was under the Biden administration. So one other just general antitrust principle applicable to mergers and acquisitions. This goes back to Section 1 of the Sherman Act, prohibiting unreasonable restraints of trade. The antitrust laws not only apply to the analysis of the M&A transaction itself, but really to the entire due diligence process, especially because if you have a strategic transaction, you might have two competitors exchanging business plans and exchanging contracts and exchanging really the competitive keys to the kingdom. And so you just have to realize when you're in a due diligence context that until the moment that you've closed, the parties are separate companies, and they really have to treat each other as arm's length competitors. So as a rule, only exchange of CSI, competitively sensitive information, that is reasonably necessary to exchange for the level of the deal that you're in. So if you're just at the initial scoping point where you're talking about the broad strokes of a letter of intent, you probably need less information than you would need to negotiate and finalize a definitive agreement. You should have a non-disclosure agreement that will provide that the information that's obtained from diligence or integration planning should only be used for purposes of furthering the deal or the analysis of the deal. As a general rule, diligence should only go one way. If it's a buyer buying a target, then the buyer needs information about the target, but the target really doesn't need information about the buyer. There are exceptions to that if, say, the buyer's taking a rollover stake, or if it's a merger of equals, then diligence is certainly too directional. But any CSI that's shared must be reasonably necessary for the recipient's consideration of the deal. So you might be saying, well, wait, I need to review the other side's contracts. That's essential diligence. How am I going to do that? And so the answer is you can create a clean team or a black box structure. I know that Michael has experience doing these, so I'll let him kind of talk about what this looks like.
Yeah, we have a lot of real world experience here, and I'd also say a lot of the compliance professionals attending this webinar will likely be involved in this, just to make sure that it's appropriate. But acquirers will use a firm like PYA to evaluate those details, but then and have access to all those details, but disclose only at an aggregate, non-confidential level. So for instance, we may perform what we would call a black box reimbursement analysis, where we, as the independent third party, have access to the commercial contracts, the negotiated rates, but we can't share that level of detail with the other parties. Any of our findings must be at an appropriately aggregated level to not disclose specific confidential information, including rates at a procedural level. Or even amongst at a payer level. So another instance is we may be doing a buy-side quality of earnings analysis for as a part of a due diligence phase. And as a part of that, we have to obtain the claims and the collections data. Well, in that particular case, we can't share that level of detail as we move forward. So we have to be very careful about that. And again, that's all to protect the clients and to make sure that the process is being run appropriately. I would like to also then go back to your prior comment on the other slide, which was your comment about integration planning is also important, because often when we do due diligence, we are also helping plan for the integration. So the information that's provided to us in the due diligence is a necessary component of what we call the discovery phase when we're doing an integration management office or any one of those and preparing for integration, coming up with that planning. So, while at some point in time for an integration, information like payroll data has to be obtained in order to prepare to cut over for day one. And you've got to understand the managed care contracts that is going to move over. But we always have to do that in concert with legal counsel to identify what information can be provided, when it can be provided, and if there are any individuals at the clients that can't provide that. So it's a very insulated process, one that I would always encourage you have counsel advising upon. So I think now we're actually transitioning to our first polling question. So we'll put that up. All right. Relevant issues in an antitrust review of a healthcare transaction include A, whether the transaction will result in price increases, whether the transaction will result in lower quality, 3, whether the transaction will result in reduced access and service offerings, 4, whether the transaction will produce merger-specific benefits, or lastly, all of the above.
So just a reminder for folks, please remember that to be awarded the CPE credit, you have to be logged in for the entire session. You also have to answer all 3 of the polling questions. We do want to hear, though, from those seeking CLE and CHC credit. So just a reminder for folks. Thanks, Michael. Thanks, Ben.
Thanks, Jana. All right.
Is one where there's all of the above is the dominant winner, and that's our intended answer. But all the answers are correct, and it really is a very open-ended analysis, which segues well to our next topic, which is the 2023 revisions in the federal merger guidelines. So we'll go through this kind of quickly, but there are these documents called the merger guidelines, and it goes back to the 1960s when the DOJ first adopted guidance for how they would approach merger reviews. And those merger guidelines were updated in the 80s and the 90s, and in 2010 under Obama. In 2020, the Trump administration, they kept the Obama horizontal merger guidelines, but they adopted special vertical merger guidelines to analyze what they vertical mergers or mergers between a buyer and a seller, in contrast to a horizontal merger, which is a merger between competitors. But in 2021 and then 2022, the Biden administration withdrew the 2020 vertical merger guidelines. And in 2023, they together issued entirely new guidelines, which they call now just the merger guidelines. They've done away with the horizontal and vertical nomenclature. But the 2023 merger guidelines adopt 11 general principles for when a merger might affect competition. And I won't go through these one-on-one. I have highlighted the ones that I think are most relevant to healthcare, but I'm really going to focus on the first one. The 2023 merger guidelines adopted a presumption that when a merger significantly increases concentration in a highly concentrated market, then they will presume that that merger is illegal. And think of it as the 3-part burden shifting framework that courts go through. This goes to that first step. The government's view is if they can prove these structural presumptions are met, then they have met that first element, and the burden falls on the parties to rebut the case. So it takes a little bit to unpack all the math that goes into these structural presumptions. I won't belabor this point, but there's this concept, they call it the Herfindahl-Hirschman Index, or HHI. It's a measure of market concentration. And it's an index that goes between 0 and 10,000. the math I spell out in this bullet point here, you take the market shares of all the participants in a market, express it as a whole number, square the shares of each individual competitor of the market, and then sum those squares. So in a market with 4 competitors, the respective market shares of 40%, 30%, 20%, 10%, it's 40 squared plus 30 squared plus 20 squared plus 10 squared, which gets you an HHI of 3,000, which is a fairly concentrated market, but not at all atypical. So in theory, if you have hundreds of firms that each have a less than 1% share, your HHI is 0. If you have a true monopolist that has a 100% market share, that market has an HHI of 10,000. So what the agencies do with the HHI tool is they consider both how concentrated is the market, and they also consider how much will the HHI increase as a result of the merger. We call that the change or the delta. The presumption that the 2023 merger guidelines adopted is that there's 2 separate presumptions. One is if the combined firm is going to have a market share greater than 30%, meaning you take a firm with a 25% market share plus a firm with a 6% market share and gets to greater than 30%, and if the change in the HHI exceeds 100, that under the 2023 merger guidelines, agencies will presume that that merger harms competition. They also have an HHI presumption that if the overall market's post-merger HHI is greater than 1,800 and the change is over 100, again, that they will presume that the market or that the merger harms competition. A delta of 100 is very, very small. So as a rule, the delta equals the 2 firms' market shares multiplied together times 2. If you don't believe me, we've got reference materials at the end. It takes about 8 steps of algebra to prove it, but we've got the mathematical proof in the reference materials. But the real takeaway here is the 2010 merger guidelines, which were adopted with truly broad bipartisan consensus under the Obama administration, had adopted materially higher presumptions. And the 2010 guidelines had adopted presumption when the HHI post-merger is greater than 2,500 and the delta is greater than 200. So there is a middle ground here that the 2023 merger guidelines have drawn a stricter line than the 2010 guidelines had adopted. And so that really is a material change. The logic of doing this, the explanation the agencies gave was, well, we're trying to provide transparency and actionable guidance to the business community to allow them to do things like when the board of directors is meeting to evaluate a merger, we want them to be able to apply these tests and really know how we're going to come out. The problem with that is HHIs and market shares require knowing what the market is. And in healthcare, there's pretty strong general practice that in at least a hospital merger, they'll define the market as general acute care inpatient services. So they'll exclude quaternary care, and they'll exclude outpatient services, but they'll look at the general acute care, the first and second level acuity. But you then also need a geographic component, and the agencies have been wildly inconsistent in how they've defined geographic markets. And these are just the cases back to 2020. They haven't followed the same approach at all. Sometimes they'll say the market is a single 4-county area in one state, or it's a single 4-county area that crosses states, or it's a 1-county area in a state, or there's a 4-county area, but there's 3 separate markets in the 4 counties. I mean, these are all allegations that the FTC has made in recent hospital merger enforcement actions. Sometimes they'll look at the entire state of Rhode Island or the Memphis metropolitan statistical area. Sometimes they'll use natural things like a lake or county lines or an interstate highway. Sometimes they'll define it based on where patients live. Sometimes they define it based on where the hospitals are. The last 2 here, this was the one case where the FTC lost a litigated challenge. They actually alleged two separate geographic markets, but those markets were overlapping each other. And that was a bridge too far for the court. But they're all over the map, and it makes it very difficult to actually provide actionable guidance to figure out, how is an agency going to review a particular merger.
Yeah, and you're not saying that the commission would use different ways to manipulate the math now, would you?
Well, I won't use the word manipulate. In fairness to the agencies, these are difficult questions, and
yes.
It's not a one-size-fits-all situation. And so, you have to draw guidance from case law. And a recent litigated hospital merger case resulted in the Third Circuit saying, the relevant markets, the area where a potential buyer may rationally look for the goods or services he or she seeks. So they say the market needs to be determined within the specific context of each case. And, maybe the commercial realities in Bergen County, New Jersey are different than the market realities in Lucas County, Ohio. Maybe it's different. So it needs to be case specific. It needs to correspond to the commercial realities of the industry, and it needs to be economically significant. So those are the adjectives that the courts adopt. Reasonable minds can always differ on how you apply those adjectives to particular facts. Yeah. A quote that I like is from the Seventh Circuit, that in essence, the question here is, how many hospitals can insurers convince most customers to drive past to save a few percent on their health insurance premiums? We should not be surprised if that number is very small. And I like that. I just think it was a nice way to reduce the issue to a commonsensical principle. But the takeaway is that a lot of times healthcare markets, geographic markets, are pretty narrow. There might not be a lot of hospitals in a particular market. With that, we're going to segue to recent reforms to the Hart-Scott-Rodino Act reporting rule. So let's kind of unpack this. So for mergers of a certain size, the Hart-Scott-Rodino Act, or the HSR Act, requires notifying the DOJ and the FTC at least 30 days before the deal closes to allow a pre-merger antitrust review. And that 30 days, sometimes it's 15 days if it's bankruptcy or a cash tender offer. It's usually a 30-day waiting period. It's a whole exercise unto itself to determine whether a transaction needs to be notified. There's a size threshold, but there's other tests. The size threshold is usually the one that people latch onto. And so the size threshold is adjusted every year based on changes in gross national product. It's currently $119.5 million, but on February 21st, that's going to increase due to annual indexing to $126.4 million. So they always change the thresholds. But if you have a deal valued above that level, you may well need to report it to the FTC. And it can be an exercise into its own right to determine, are we above that level? Or are we below that level? I mean, if you have, say, two nonprofits that are coming together in a cashless transaction, you may well have to do a fair market valuation to apply the threshold. So again, it's often an exercise into itself. But historically, the vast majority of transactions that are notified don't lead to anything further. It's about 97% of HSR reportable transactions get cleared within that 30-day waiting period. However, the remaining 3% garner a more in-depth investigation, which we call the second request. And the second request, we can spend hours just talking about a second request. We picture millions of documents and terabytes of data. And the way the HSR Act works is you can't close your transaction at least 30 days after you've complied with the second request. So this is all just to explain what the HSR Act is. The reforms that were adopted in 2024, it was late 2024, November, they're really fundamentally rewriting the requirements for the information you have to include in that initial filing notified to the FTC and the DOJ. So this isn't just applying to the 3% of transactions that get a second request, but it applies to the 100% of transactions that are notified under the HSR Act. The picture here is the moving of goalposts, because this is all really, really in flux. So the rules were adopted or finalized in November of 2024. They're not supposed to take effect until February 10th, meaning for transactions that are reported on or after February 10th. But these changes might get delayed or even further changed by the incoming Trump administration. It's a very live issue, and those of us who practice HSR law are on pins and needles to see what happens. But I'll go through this quickly. Historically, you only had to provide information in an HSR form about your own business operations, but what they're now going to require is that you actually write a narrative and identify, are there any competitive overlaps between the one party to the merger and the target to the other? You actually have to stake out a position on the issue of, is this transaction going to lessen competition? You have to say, yes, we compete. And if we compete, you have to identify the top 10 customers that you supply, which in the healthcare industry would tend to be commercial payers. You might have to do that by different segments. They might look at commercial payers, but then look at, say, self-pay, or if they're direct employer contracts. Another change that's going to be included in these HSR reforms, this is a complicated one, but on the buy side, they want you to identify, do any of your officers or directors serve as officers or directors of other companies that compete with the target? And if so, they want a disclosure of who those people are. It's a complicated concept to explain. It's an even more complicated concept to try to apply in practice. So this is going to be an issue. And in healthcare, where you have all these entanglements, we've got people serving on the board of a joint venture ambulatory surgery center or what have you, could really be very difficult to try to unpack this. They want information about any minority investors on the buy side. One of the biggest parts of an HSR filing historically were their document requests. You always had to provide documents that were prepared by or for any officers or directors that analyze the transaction with respect to things like competition or markets or market shares or what have you. They're expanding those document search requirements to include not only officers or directors, but also supervisory deal team leads, which is not an incredibly well-defined term. They're expanding the rules for when a draft document needs to be included. They're also, when the parties have an overlap, or requiring the submission of certain ordinary course documents prepared in the past 12 months, specifically any regularly prepared plans and reports that relate to the overlap market that were provided to the CEO in the past 12 months, or any plans and reports provided to the board that relate to that overlap industry.
And Ben, I think that's going to be really impactful here, because working on to help advise clients on both the sell side and the buy side as far as these transactions. I mean, there's multiple conversations that occur. There's multiple business cases that are prepared. Seems to me like we've got to be talking about this on the very front end, on the conceptual phase, to make sure that there's proper counsel throughout the process to ensure that any of those drafts that they are appropriately structured to not cause a problem during the HSR review.
Absolutely, and this goes back to what we're saying at the start, that the words that people use in documents can be tremendously impactful on how an investigation goes. So words matter here. It just underscores how important document creation is. So there are a lot of other parts of these HSR reforms. I won't go through them one by one. One that I will say that will be annoying in healthcare is expanded requirements for identifying prior acquisitions. I'm thinking, if say there's a physician service acquisition, you're going to have to list a whole bunch of onesie twosie acquisitions going back 5 years. It really is going to be a beast. So we'll see if these reforms stick or not, but assuming they do, I expect, in fact, I'll ask you, what do you think will come?
Yeah, so with the second polling question, everyone, if you can be ready for that. So it's up on the screen now. What do you think is going to be the most likely outcome of these reforms, the HSR reforms? Higher rate of second requests with better identification of problematic deals, smaller rate of second request from better identification of non-problematic deals, fewer transactions attempted due to the disclosure requirements, or more time, costs, and headaches for preparation of the HSR filing.
As a reminder, CPE participants, please answer the second polling question. This is number 2 out of 3. CLE and CHC participants, you're not required to answer the poll, but we sure would love to hear from you. We've got a lot to do in the last 10 minutes of our time together today, so please answer this polling question. There's another polling question to follow. And just as a reminder, this CEU survey is located on your webinar dashboard, and you can access that at any time. So please be sure to take a look at that and check that out as well. Michael?
Yeah, and we'll move quickly through the last few. Go ahead, Ben. I'll let you.
Yeah, I mean, the bottom line here is, I think, very consistent with what the predominant response was, is this is going to be a headache, and it's going to take more time and effort and cost. It's been a whole hour on that, but timing of the essence. Let's talk to what's happening at the state level. And I call these mini HSR acts. Over the past, let's say, decade, states are increasingly adopting laws which tend to be specific to healthcare, where state enforcers want to review transactions. And sometimes they want to review transactions for classic antitrust purposes, but sometimes it's a more broad, holistic review. And so California, Illinois, Massachusetts are all states that are out in front. They've each adopted their own special tests for what transactions need to be reported to whom and what the waiting period is. But I won't go one by one. I'll say there's a lot of these. And in fact, just today I learned that New York, which is on this list, there's a bill proposed to even expand the reporting requirements further. So this is a very live issue, and the direction seems to be towards more and more notification and more waiting periods. But
I'll also just mention, Ben, to the audience, that it's really important to understand what the nuances are of each one of these, depending upon where your transaction. There's a lot of cross-border transactions occurring, but they all have different nuances. So engage counsel early.
Absolutely. These are complicated laws, and they're fast changing. On the other end of the spectrum, some states are adopting laws that have the effect of immunizing a transaction from federal antitrust review. We call these a COPA law, or Certificate of Public Advantage law. And the idea is that the federal antitrust laws are interpreted to not apply to conduct when a state has clearly articulated it is actively supervising an alternative form of regulatory oversight. And so in healthcare, some states have adopted laws, or the states are listed on the screen. They've adopted laws that say we're going to immunize these healthcare transactions from federal antitrust review, provided that the parties apply for and receive a certificate of public advantage where we as the state have blessed the transaction. The FTC hates these things. In 2022, put out a paper arguing that these are an inadequate alternative to promoting competition among hospitals. But, it's a pretty hot trend. And I know Michael has experience actually applying COPAs.
Yeah, we've worked with clients in the past in multiple of these jurisdictions that have COPAs for time purposes, so we can keep moving on. We'll keep going, but happy to follow up with anybody as that may be interested in COPAs afterwards.
So we're going to end by looking forward and scanning the horizon for what's to come with the incoming Trump administration. And they're just saying personnel is policy. We know who Trump's nominees are going to be. So Trump has nominated to head the Department of Justice's Antitrust Division an attorney by the name of Gail Slater, who was a economic advisor to J.D. Vance when he was a senator. But before that, she was an FTC staffer. At the Federal Trade Commission, so the way the commission works, there are 5 commissioners at a time, and they have staggered terms. So Trump doesn't get to come in and have a clean slate. But so there's 5 commissioners. He has nominated, there's one opening, and he's nominated an attorney by the name of Mark Metter to serve as the 5th FTC commissioner. He will step into the role, assuming confirmed by the Senate, he'll step into the role or the seat that's currently held by Lena Khan, who was Biden's FTC chair. To chair the FTC FTC, Trump has appointed Andrew Ferguson. And Andrew Ferguson was first appointed to the commission by President Biden. And he's been confirmed by the Senate. He's been a commissioner since last spring. There's no separate step required for Trump to elevate a commissioner from commissioner to the chair of the FTC. So Trump just went ahead and appointed Ferguson to serve as chair, and that has taken effect. They updated the FTC website within about an hour of the presidential change on Monday. So we have a new chair, Andrew Ferguson, and the way it's going to work is Lina Khan is stepping down from the commission next week. So there will be two Republicans, 2 Democrats serving as commissioners until Mark Meadow is confirmed, at which point the Republicans will have 3 commissioners to the Democrats 2. I've seen some reporting that suggests, hey, the gloves are off. They're going to go forth and merge. They're not going to enforce the antitrust laws anymore. I don't think that's the case at all. These are all really experienced, disciplined, committed antitrust enforcers. They've all worked in government. They're all passionate about antitrust law. They're particularly passionate about big tech, antitrust issues involving big tech. But these are serious people that they're not going to just take the gloves off. They are going to enforce the laws. So I'll call this evolution rather than a revolution. But on the margins, there will certainly be differences. And so we've talked about some of these, but just to recap, more focus on harms to patients or payers, less focus on harms to workers or suppliers. A big thing that the Biden administration's antitrust enforcers, when they found a deal that they didn't like, they would generally litigate it till the end. I mean, there were a couple exceptions, but they were very hostile to working out a divestiture or some sort of remedy. I would expect the Republicans to be more open to, hey, let's work out a deal. Let's negotiate a divestiture or other sort of remedy. They'll probably on the margin be a little more open to crediting efficiencies or synergies arguments. And they'll probably be, again, on the margin, a little less hostile towards private equity and private equity profit incentives. The marginal differences in how you analyze HHI and market concentration. If your deal is on the margin, then these marginal differences can be very consequential. It could be outcome determinative, but then less openness to really novel, thinking outside the box types of enforcement theories, especially in vertical deals. I think Trump's people are going to be more open to vertical deals, and maybe slightly less burdensome processes for second requests. Now, there is the potential for some more significant changes, like we talked about delaying or revising the amendments to the HSR rules, potentially revising the 2023 guidelines, possibly even reverting to the old guidelines or coming up with entirely new ones. You could imagine some structural changes like reducing the budgets or the staffing of the agencies. There have been some proposals, Trump's people couldn't do this, but there have been some proposals among the Republican Congress people to eliminate the FTC entirely and just consolidate federal antitrust enforcement at the DOJ. So they've been talking about that for a long time. Now is as good a time as any for that to become a live issue. So that could potentially come up. And then you can also imagine using antitrust as a tool for, say, blocking Chinese influence or restricting foreign ownership of U.S. Or allied businesses. So that's what could potentially come. Michael, the last question.
Yeah, now time for everyone else to pull out your crystal balls and answer this question. So how do you think the new administration's nominees will affect antitrust policy and enforcement in healthcare? New administration will maintain the same high level of scrutiny as the Biden administration. The new administration will lessen the level of scrutiny. The new administration will heighten the level of scrutiny, or the new administration will rewrite the playbook completely.
All right, folks, please remember to be awarded CPE credit. You have to attend the entire session and you have to answer all 3 polling questions. This is the 3rd and final. Again, for our CLE attendees or CHC attendees, we do welcome hearing from you. So please let us know your thoughts.
Sure. Interesting opinions. I think probably about right. It'll be a mix of marginally lessening scrutiny, but then some entirely new tools and ways of approaching these issues. So it's very interesting responses. With our remaining minute, I want to point you to reference materials, and this presentation is available to you all. But we've got a link to the merger guidelines. A few years ago, the FTC put out a pretty good blog post about antitrust issues and due diligence. So I would commend that to you. Links to the HSR changes and the FTC's policy statement on COPAs. And I alluded to, if you want to see the 6 steps of algebra to prove how HHI deltas can be quickly calculated, I've got a blog post of my own. So with that, thank you all for attending. Hope you found this valuable. If you have any questions, don't ever hesitate to reach out directly to myself, to Michael, to any of us. Thank you for attending.
Thank you for listening to this PYA webinar recast. The video recording, slides, and associated material for this and all PYA webinars are available on our website. If you have any questions or if we can help, please contact us at pyapc.com. Thank you again for joining us, and have a great rest of your day.